Uh, Please tell us your name and roll number for this exam.
Uh, yes, sir. So my name is Karonika Ghosh, and my roll number is 400343 for the OJS exams.
Okay, without mentioning your name, please give us a brief introduction.
Um, I studied law and I graduated from National Damodaran Sanjivaya National Law University, Visakhapatnam, in the year 2020. And I have completed my master's from ICFI Law School in the year 2021. During my LLB, I was the silver medalist of my batch, and during my LLM, I was the bronze medalist of my batch. Uh, Apart from that, I am currently working now as a placements manager in a startup where I counsel students. I counsel law students in choosing a better path in their legal career and helping them with their careers.
Okay. Uh, what are your hobbies that you have mentioned in your CIF?
Sir, hobbies, I don't really have any specific hobbies. In my pastime, I like reading books. I like reading mystery books, thriller books. Apart from that, I don't really have any such hobby because I'm so consumed with my preparation and my job that I don't really get such free time.
Okay. Uh, Give me some good reasons why you are interested in joining the judicial services.
The judiciary has always been a dream for me. I joined the law university dreaming of becoming a judge because it is such a prestigious role where you can impart justice without any biasness and without any pressure from other verticals. And I feel I can do justice as a judge, more as a judge rather than, in any other field of law.
Okay. What are your special achievements that you have given in your CIA?
So during my law university days, I was awarded the best speaker for a national moot court competition, which was organized by Trans India Associates Law Firm, and also I was our team was granted the best memorial award in the Christ National Law University moot court competition. So these have been some of my achievements in law school. Apart from that, my personal and professional achievement would be that I have helped around uh, 400 plus students get internships and jobs during the pandemic period, where law students were feeling very demotivated and they could not find any scope in their career. I help them in getting connected with good opportunities, and I also counsel them in getting placed at better places.
Okay, fine. So you said you do not have any specific hobbies. Okay. Um, so let us go to procedural law now. Let's start with criminal procedure. Can you tell me what are the different types of trials under the CRPC?
um, so there are three different types of trials. There is summon trial, a warrant trial, and there is summary trial.
Okay. And what is the sessions trial?
Sessions trial is a proceeding that takes place in the court of sessions.
Okay. Summary trial, when it is used, and what are its features? Who can order for a summary trial?
A summary trial can be ordered by a chief judicial magistrate or a metropolitan magistrate or judicial magistrate first class, and it is ordered in the case where the punishment does not exceed 2 years, and in subject matters where the cost of the property does not exceed rupees 2000.
Okay, and it can be this summary trial. Okay, can be ordered by whom?
By chief judicial magistrate and metropolitan magistrate and judicial magistrate first class. Special.
Can it be done by judicial magistrate second class in any circumstance?
If he or she has been specially empowered.
By whom? Empowered by?
By the, I am not really sure about it, but is it chief judicial magistrate?
Okay. Can the High Court empower him?
I'm not really sure of the answers.
Okay, just you can go through that. Okay.
Okay,
right.
sir. Definitely.
Is there any provision in CRPC which talks about which gives the power to a common citizen to arrest an offender, arrest an offender, and after that, what is the procedure he has to follow?
Yes, sir. There is definitely a section in CRPC regarding where a private person can arrest an offender. It has been mentioned under section 43 of CRPC, where a private person can arrest an offender if he's committing a cognizable offense, and later he can pass on that person to a police station who will re-arrest him again if they are satisfied that that person has committed an offense, prima facie any cases.
Okay. So under CRPC, can you tell me what is the concept of plea bargain and what are the exceptions to plea bargain?
Yes, sir. Chapter 21A of the CRPC deals with the concept of plea bargaining from section 265A to 265L. It was introduced by the Criminal Amendment Act of 2005. So, plea bargaining is when the accused gets into an arrangement with the victim that some of his charges will be reduced or will be reduced to a lower charge, and some of the examples where some of the exceptions for plea bargaining would be socio-economic offenses, where the offenses are really so grave that they cannot be subjected to plea bargaining.
Okay. For example, what kind of offenses in which plea bargain cannot be allowed?
So, for example, one example would be white collar crimes, where lots of money is involved in a company, and then lots of corruption is taking place. So, their plea bargaining cannot be allowed.
Okay. Socio-economic crimes, crimes against women, children, okay, below 14 years of age. Okay. So all these things would go under that. Okay.
I'll keep that in mind.
Okay. Can you tell me the stages of a criminal trial, starting from the registration of the FIR, okay, till the conviction? So stage-wise, what is the process that is followed? If you can explain.
The stage one would be giving of the FIR, and stage two would be investigation. investigation by the police if it is done by if it is a cognizable offense, and investigation by a magistrate if it is investigation ordered by a magistrate if it is a non-cognizable offense. Uh, Third would be inquiry. Fourth would be trial, and then fifth would be conviction.
Mhm. Okay. So suppose a court has given. So which is the lowest court which can give death penalty?
Court of Session, sir.
So it has given death penalty. Okay. What is the process after that?
So then it will go for confirmation under section 366 of the CRPC to the High Court, where at least two High Court judges will confirm the death penalty. Only then it can be given.
Hmm. Okay. So what is the, according to you, what is the most important, okay, section in the civil procedure code, and why?
Under the Civil Procedure Code, according to my beliefs, it would be section 151 of CPC, which gives powers to do justice to the courts, where even if some procedure is not mentioned under the CPC, the courts can to do justice to the parties, can uh, give their own judgments.
Okay. So under the CPC, can you tell me what is the difference between res sub judice and res judicata?
Yes, sir. Section 10 and 11 of the CPC deals with res sub judice and res judicata respectively. Section 10 basically deals with stay of suits, where if a matter is already in issue directly in another in another court between the same parties who are litigating under the same titles, uh, then it cannot be a suit cannot be filed. Such suit would be stayed by the subsequent court if such issue is already in discussion in another competent court. But in res judicata goes a step further than that, where the issues has already been decided between the same parties under the same title by a competent court. Then again on the same issue, another case cannot be filed, because we have to stop this litigation somewhere, so that the parties are not involved in going round and round in litigating cases.
Okay. So tell me what is the meaning of an estoppel, and differentiate between an estoppel and res judicata?
Estoppel, sir, is a rule of evidence where if I have already uh, said something, and on the strength of that, the other party has done something, and has done something, or has taken some actions, then I cannot go back on my words and later claim that I have not spoken, I have not told such things. So this would be like the Supreme Court has said, that I cannot blow hot and cold at the same time. I cannot say one thing and later claim that I have not said the same thing. So this is estoppel. Res judicata is basically where a court has already decided on a matter. Then a subsequent suit cannot be filed on that matter which has already been decided.
Okay. What are the types of estoppel that you know?
I know of one estoppel which is promissory estoppel. If I may explain about promissory estoppel, I just know of one estoppel only.
Oh, yeah, you can go through other types of estoppel also. Okay.
Okay.
Is there any provision in the CPC which empowers your civil court to order the arrest of the defendant before the judgment?
Yes, sir. Order number 38 deals with the procedure which deals with arrest before judgment. If
Hmm.
a if a if the court finds it that the person is trying to delay the proceedings or is trying to run away from the jurisdiction of the court, then the court can order for the arrest of such person and may ask for uh, a reason why he should not be asked to give security amount for his conduct.
Okay. So coming to Indian Evidence Act, can you tell me what are the exceptions to hearsay evidence?
Yes, sir. Sir, hearsay evidence, even though it is not accepted under Indian Evidence Act, some of its exceptions are uh, res geste, which is under Section 6 of Indian Evidence Act. Then there is another dying declaration under Section 32, where a person makes a declaration on his deathbed. And another exception that is coming to my mind would be opinion, expert evidence under Section 45 of Indian Evidence Act. These are some of the exceptions that I can think of.
So suppose a witness has turned hostile. So whatever evidence that hostile witness has given, should it be thrown out or some part of it can be used in the case?
It cannot be thrown out in its entirety. It can still be used in the subsequent proceedings, depending on the discretion of the court.
Okay. So what do you mean by privileged communication? Give some examples of privileged communication.
Sir, one example of privileged communication would be communication made during marriage. So when a husband and wife, if a husband confides something to his wife, and that is during the existence of his marriage, even so that cannot be given as an evidence in the court of law, because that would be considered as a privileged communication, sir. Uh, Another example would be when a client is confiding something to his advocate under Section 126 of Evidence Act. But there are some exceptions to it, where if the advocate comes to know of any crime that has been committed after his engagement, or if or of an or of a communication in furtherance of a crime, then he can give up this privilege and give this thing as an evidence.
Okay. So fine, that will be the end of the interview. So now the assessment. So most of the questions you are able to answer properly. Okay. And content of the answer was fine. So what improvement you can do is like, see, if they ask you a question, you are in doubt or you don't know. So from the beginning, you just tell them that you are unable to recall it. Don't give wrong answers. Don't try to bluff or guess. Okay. Even 5, 6 answers, if you are unable to say it, doesn't matter. Okay. Even 3, 4 answers, if you answer properly, you will get the required marks. Good marks you will get. So that is one part. Second is regarding eye contact. Eye contact here in virtual mode, I'm unable to analyze properly. So eye contact during mirror interviews, take care of eye contact. That the person who is asking you the question, you have to look into his eyes for 80-90% time, and 10% rest other members, board members. Okay. So rest things are fine. When is your Viva?
Sir, it is on 30th of October.
Okay, still have some time, so please take care of that. Okay.
Sir, can you tell me which all answers I answered wrongly? Maybe I can.
I don't remember all the questions. Okay. Some of them which I told you, just you can check that. For example, estoppel. Okay, you said that you only remember promissory estoppel, but estoppels are of different types. Okay, more types of estoppels are there, right? You can just go through that.
Evidence
Those
Act?
parts.
That would be Evidence Act.
Exactly, yeah.
Okay.
Right?
Okay.
So we'll stop then.
Okay. Thank you, sir. Thank you so much.
Thank you. Thank you.